Inside the courtroom, tension rises as the defense accuses the system of being unfair, and the judge pushes back. Everyone, please sit down. Your Honor, once again, I am asking for a mistrial. We are not allowed to challenge the witnesses. We are not allowed to argue consent. The prosecution is allowed to present things that we are not. We cannot respond to the accusations in the indictment. This is unfair. This trial has been worse than practicing law in communist Russia. My client does not stand a fair chance in this courtroom. Your Honor, the witness gave a previous statement. We played that recording for the court. In that statement, the witness said the person was wearing a bright shirt, orange or red.
Right, that is a quote. We played the recording. The Honorable Court was able to hear that recording. Her testimony here today was that he was wearing a hoodie. This is important because the state wants to make all the people that were seen in the neighborhood Mr. False. The person that they brought, the first witness in for, said, oh, he had a jacket. So, of course, they want her to say, oh, he had on a hoodie. It's an inconsistent statement. We are handcuffed, Your Honor. We are asking for a mistrial in this case.
Thank you. Mr. Bolden, do you care to respond before I make a response?
Your Honor, Mr. Cruz has failed to make the proper foundation for a prior inconsistent statement. He has not asked the witness a question that the witness then denied. And so it's just not a proper foundation. So that's the basis of the state's objection. As to his motion, I don't necessarily think I have to make a response.
All right, thank you, Mr. Bolden. So, Mr. Cruz, the first thing I want to say, and we are outside the presence of the jury, is that it is unfortunate that your constant comments about the unfairness of this trial it's very unfortunate. You know, it is outside the presence of the jury, but it is not appropriate to continually just argue to the court that things are unfair and that somehow the defense is handcuffed because of the court's rulings. As I stated before, the court endeavors in every respect to make rulings based on law. So that's the first thing. And, you know, having a slight tantrum every time you get a ruling that you don't agree with is really not appropriate. And I'm going to ask you to consider that moving forward. The second thing is the state is correct, Mr. Cruz, in terms of the procedure to request to admit an inconsistent statement, and you have not done it properly. I will say, for the record, in this particular moment, that your question was not the appropriate question to ask to recognize an inconsistent statement. It was kind of a trick question of sorts. You asked her to describe that particular piece of clothing, and her response was, I would say it was a hoodie, as if there was sort of The
question allowed the witness to choose how to describe the clothing. She could say it was a shirt, or she could say it was a hoodie. As I understood the testimony, she chose to describe it as a hoodie. If you want to argue that this counts as an inconsistent statement under the law, I will listen. If not, I will sustain the objection and ask you to move on. You may respond.
And then I'll talk about the mistrial in just a moment, but go ahead.
If the Honorable Court has the statute, just save me a little time. I'm pulling the statute now, if that's okay. But if you have it readily available.
Well, I mean, Mr. Cruz, I'm not going to advise you on the law. And I think you need to be here prepared to argue it.
No, I just said if you had a copy of the statute, I was just trying to save it on the course of time, but I'll pull it up there. This is OCGA. The statute is OCGA 24 6-613. Prior statement of witness is the title of that section. Under subsection A, the law provides, in examining a witness concerning a prior statement made by the witness, whether written or not, the statement need not be shown nor its contents disclosed to the witness at the time. Provided, however, upon request, the same shall be shown or disclosed to opposing counsel. Your Honor, in this case, I went above and beyond. I actually chose to refresh her recollection as opposed to impeaching her when we were talking about her statement. She heard the entire statement. I told opposing counsel, this is what I have. They heard the entire statement. Subsection B provides, except as provided in Code Section 24.8.806, extrinsic evidence of a prior inconsistent statement by a witness shall not be admissible unless, first, the witness is first afforded an opportunity to explain or deny the prior inconsistent statement, which we did.
Your Honor, this is a direct quote from her statement. I read it exactly as it was written. She said it was a hoodie. I confronted her with the prior statement and gave her the chance to explain. She still chose to say it was a hoodie. The law allows the opposing side to question a witness about inconsistent statements. The state will have the opportunity to examine her on this issue. Mr. Cruz, what specific statement are you saying is inconsistent with her testimony?
Testimony. Sure. I think that's part of what the state was endeavoring to argue. So what is it?
So the written question that I asked, the individual that she saw walking, did she state he was wearing like an orange-colored shirt? She said that he was wearing a hoodie.
Well, that wasn't the question you asked, Mr. Cruz. The question you asked gave her an option to sort of describe what she meant. And you said something to the effect of, was it like a hoodie or a shirt? And she opined it was like, I'll say, a hoodie. I'm not sure that's an inconsistent statement, but I will let you question this witness again with specific questions if you would like to elicit the proper information for the court. I will let you question her right now out of the presence of the jury, and we can go from there.
Sure. In your prior statement in law enforcement, did you state he was wearing like an orange-colored shirt, orange or red, something bright?
Yes.
We can bring the jury back in. That's it.
All right. And, Mr. Cruz, I want to comment on your motion for mistrial.
Sure.
I'm going to deny that motion. The granting of a mistrial by the court is a very, of course, as you are well aware, extreme option. And it is done in very limited circumstances where the matters that have been presented in court are of such a prejudicial matter, such a prejudicial level that the defendant cannot receive a fair trial. And with regard to your motion, you have not sufficiently shown this court that that exists. And so I'm going to deny your motion. All right. Can you bring the jury in, please? Thank you.
The argument continues, but one question remains. Is this justice or just procedure?